Hello everybody, and thank you for tuning into our webinar dealing with Project Distress, a toolkit for success. This is part of a regular series of content hosted by Ankura, and if you like what you hear today, as we hope that you will, then please follow us at ankura.com or on LinkedIn or on Twitter to find out more about our other events. You might imagine from the title of today's webinar that our subject matter is all about things going wrong. Well, it is, but the silver lining to this is that there are always telltale signs and advance warnings that would give you the chance to take an action in an intelligent way. And our aim today is to help you get good at spotting those signs and taking the right action to correct things if you can. My name's Rob Jones. I am a Managing Director at Ankura. It's my pleasure to introduce two excellent speakers today. Ben Giaretta is a partner at the law firm Mishcon Reya, and my colleague Andrew Jeffery is a Senior Managing Director at Ankura in the Capital Projects team. Now, recent events on the international stage have shown us that the world really has become quite unpredictable. Now, more than ever, is the time when clients, project owners, developers, governments, risk managers, basically anybody with a responsibility for infrastructure, construction, and real estate delivery absolutely has to be on top of their performance issues and metrics. And this is where we see two dynamics converging. First of all, how to spot the signs of distress before things get really bad. And second, the action that you need to take to get the best possible outcome. Now, Andrew, would you like to talk us through the issues that you see on an operational level?
Thanks, Ben, and welcome to everybody. Yeah, I think first of all, I would say that what we're attempting to do through this process is to get onto the front foot. If we can understand what's going on, we can move forward and we can therefore act in a very beneficial way. So in order to do that, I've grouped this as three subjects really, very familiar terminology to all of us in the industry around time, cost and quality. Certainly from time, really stress is often, or distress rather, is often manifested in project delays or procurement delays, out of sequence working on sites in the construction activities, disruption as well to the works is very, very common, and these are really key signs. From a cost perspective, the increase in costs often due to change variations, claims, escalating contractual correspondence, as well as payment delays are very, very common to most people, I'm sure. The one I would ask and sort of highlight to really sort of keep a note on is any request for advance payment should be treated with a very keen eye to understand the reasons for this. Next, from a quality point of view, and when I talk about quality in the broadest sense of the word, we're looking around what is the quality of the reporting, of the controls on site and the communications into actually what's going on. Are you in control? Or next, quality issues typically manifest with issues to do with poor workmanship. Again, clear early lead factor. Supply chain is something, especially over the last few months, something really important to look at is understanding where the supply chain is and where are the risks within the supply chain, which can quite quickly snowball upwards. And finally, from quality, it's watching out for staff attrition. Key staff leaving projects tends to be a lead factor, which employers need to be aware of.
Thanks very much, Andrew. And Ben, what are your views?
Thanks, Rob. So when I'm brought into projects that have got into distress, what I typically see are, firstly, the parties have little true awareness of their rights and obligations. They may be aware of their project schedule and the overall obligations they have, but they don't really understand the detail of their rights and obligations. And also when it comes to the implementation of the project, I've often found that you may see the wrong people are involved in it, meaning that while the people on the ground on the project site may be pushing forward with the project, there isn't proper oversight from head office, from senior management into how the contract is being implemented. And one of the main things that then happens is that parties may miss deadlines under a contract. They may be so focused on the project schedule and achieving that they miss, for example, a deadline for the service of a notice. I also very often see a breakdown in communication between the parties. It's very easy on a construction project to send letters back and forth, but I very often see correspondence which has no real purpose to it. The parties are focusing on their rights and use their letters to simply recite different clauses in the contract, rather than focusing on solutions. And overall, this means that there's a complete failure to connect between the parties. And as a result of that, you very often find that the parties have got into a mindset where they are storing up their claims for the future. You might call it an arbitration mindset. They are thinking in terms of having a big arbitration at the end of the project. And that when you get into that mindset, that almost inevitably means you actually will have an arbitration at the end of the project.
Thanks, Ben. So in terms of solving these issues, Andrew, what are your thoughts?
Thanks, Rob. I think, as you've said, and as the listeners will be very aware of, is actually all projects deal within risky environments, whether it's at home or abroad. And by the nature of our industry, with things being one-offs, it's something which we live with commonly. So what we're talking about here is the more extreme cases, which then cause, sort of contractual issues to the parties. So really, I see 5 measures as being very important to sort of really to identify and get on top of what to do. The first one is to rapidly evaluate what's actually going on versus what was planned to happen. How bad is it is clearly really important in order to understand what measures and time available you've got in order to address these issues. The next one is to evaluate as best one can the positions of the parties, yourself and also the other stakeholders, to understand what's probably gone on. It may not be as clear from a factual point of view, but really to get a sense of, kind of why is it kind of got to this position. And most of us, given, sort of support and some clarity, can come to a reasonable position on this. The next thing then is to look at really issues to do with time and cost, the bankability of the scheme, if you like, in the fact that if something is in significant delay, what does that do as far as the funding requirements on the project? And does that have any implications to the client or the contractor for it? The next is really, really important, and I would sort of underline this, is having the right advisors with you to understand what is the willingness and capacity of the parties in order to look at options. Ben's just mentioned about sort of the arbitration mindset. It's important at this stage to try and keep as much communication as open as possible, and arbitration and any sort of formal sort of position to be the last resort. This is about getting around the table, looking at plans, looking at options, understanding what can be done, and really focusing on turnaround on the basis this is the right time and it may be your only time.
Thanks very much, Andrew. And Ben, from a legal perspective, what should clients be doing?
Thanks, Rob. So from a legal point of view, there's various things that parties should do. First, of course, they need to properly understand their legal rights and obligations. But what's said on the contract is not the whole story. One also has to analyse what has actually happened in the project, what has actually happened in the implementation of that contract. And that involves assembling all the documentary evidence. It involves speaking to the key people involved in implementing the project. And having gathered together that information, it's important to sit down and truly think through your position, not only your legal position, but also your commercial position. And that could be done by a brainstorming session, for example, involving a group of people getting together. But if you're in a group discussion, it's very easy to fall into groupthink, meaning that you could get onto a one-track mindset and not really thinking about the problems with your position and the weaknesses with it. So I often find it's a very useful exercise to try to challenge your position. You might do this via a mock arbitration or a mock mediation and work through what are the strengths and the weaknesses of your position. And having done all that analysis, then it's important to approach your communication with your counterparty in the right way. And that includes letters being sent by people who have the authority to negotiate on your behalf. It includes writing in order to make constructive suggestions, not simply to score points. One needs, of course, to write to preserve your position very often, but it's important to see correspondence as a way of moving things forward whenever you can. And one of the ways you might move things forward is by using without prejudice correspondence. That's correspondence that cannot be referred to if there is an arbitration later in the day. Using that label very often means that the parties can engage in a more commercial discussion rather than being very anxious about their legal position.
Thanks very much, Ben. So it's time to bring things to life. Andrew, would you like to start by sharing your international EPC contractor story?
Yeah, thanks very much. I've picked this one because I think it demonstrates, clearly the difference between sort of the best endeavours of teams versus the corporate sort of imperative. This was an EPC contractor, international, and we were brought in. They had won a portfolio of projects for a client, about half a dozen rather, projects, of which there were 2 major projects and 4 slightly smaller projects. And on the 2 major projects, the board were concerned about the volatility of reporting. Some months going into profit, some months going into loss. And so we were asked to look at sort of the forecasts. And what actually this showed us was that the 2 big projects were actually under significant distress. And at a project level, they'd taken localized views in order to buy time to sort of try and resolve it. What this actually had meant is that 2 things. First of all, they had burnt valuable cost in resources to try and resolve it. But more importantly, they were at the back end of both projects, and they were very close to LED provisions under the contract. So they were running not only the time of the resources to try and sort the issues out, they had the real looming impact of LEDs. The net effect, unfortunately, was that both of the major projects, the losses were so substantial that as a portfolio, the portfolio also lost significant amounts of money, requiring our client to inject capital into the business in order to sort of keep things afloat, let alone the reputational loss that the company suffered. What we learned from this really is that there was little governance and controls to ensure that the projects were reporting accurately and giving the board the opportunity. And by keeping it from themselves, they were actually exposing, a lot of unnecessarily distress, which had it been spotted earlier, could have been designed out from the start.
Excellent. Ben, over to you.
Yeah, I want to mention 2 projects that I've been involved in. One was about the construction of power stations in a country in South Asia. And this is really an example, quite an extreme example of a failure to communicate. I was actually one of the main subcontractors, and the main contractor in that case got into financial difficulties, with the result that many of the people involved at the contractor simply disappeared. They either moved back to Europe, or else they found themselves in a position where they could not give any proper communication, they could not take any decisions. And of course, working for a government ministry, who was the ultimate employer, one found that the people in the ministry, the civil servants, very often refused to take proper decisions either. So my client, the main subcontractor, found itself in quite a bit of a bind because it couldn't really communicate with anyone in a meaningful manner. And the other project I wanted to mention was a project in Malaysia concerning the construction of oil rigs. And I was brought in after the head office found that the budget of that project had been exceeded after only half the work had been completed. And they wanted to know why they got into this problem. And when I went in, I found that the project was in quite a disarray. The documents were in no discernible order. It was quite difficult to work out what had actually happened. And there had also been multiple changes of personnel. So it was quite difficult to pin down in conversations with the people involved exactly what had happened. So those are two examples of projects that had got into distress.
Brilliant, thank you very much. So in a nutshell, prevention is clearly better than cure. Disputes come at an enormous cost, not just in terms of fees for experts and lawyers, but in terms of management time and focus as well. And it really is better to deal with things up front than to let them fester. At this stage, I'd like to thank Andrew and Ben for their insights today. If you have any questions arising from this discussion, we'd love to hear from you. And we look forward to seeing you at another event. And thank you very much for tuning in.